All right, here we go. We are live, everybody. Thanks again for joining us tonight for another live Q&A webinar from Upsolve. If you've been here before, welcome back. And if this is your very first visit with us, thanks for joining us. We are really happy to have you here tonight. My name is Ben Jackson, and I am one of the co-founders of the nonprofit Upsolve. And if you're here tonight, the chances are you or somebody you care about is being sued for debt, or at a minimum, just really struggling with their debt. So maybe you've received a summons, you've gotten some collection calls, or you're thinking about whether to settle or to file for bankruptcy. And that's exactly what we're going to be talking about tonight. Now, this is something I care about really, really deeply because I've lived it. Back when my small business failed, I was driving for Uber and Lyft. I had 60 grand in debt. I was only making $20,000 a year, and I was drowning. I ended up on food stamps, and I was so embarrassed and so scared that I didn't have a way out. And I found bankruptcy, and it gave me a lifeline and helped me get back on my feet. And filing was one of the hardest things that I've ever done in my entire life. The decision to get there in the first place, deciding to do it, doing it, it was so stressful and so challenging, but it gave me that second chance that I needed to get back on my feet. And that's what led me to co-found the nonprofit Upsolve. And it's why I feel so passionate about helping other people understand their options as they go through the debt relief process. So this is going to be a live webinar. So we'll be taking your questions in real time. We have some questions that users have submitted ahead of time, and we're going to answer them as best we can as they come up. Drop them in the chat, and I will bring them up in the conversation. You're not alone in your debt relief process. That's why we are here to help tonight, as well as everybody in the audience. And I'm excited to get started. So tonight we are welcoming back Yale Levy from Solo. Now we're going to be diving into some new questions and challenges than what we covered last time. So if you want to hear more about our past conversation, you can check that out in our YouTube feed. And here's what we're going to talk about tonight. What does it mean to be judgment proof? What do debt collectors know that they don't want you to know about debt lawsuits and your rights along the way? How you can handle multiple debt lawsuits at the same time, and the dangers of so-called zombie debt. We're also going to talk about how tech tools like Solo are really changing the game for people who are dealing with debt collection lawsuits. So without further ado, welcome, Yale. It's really good having you here tonight.
Yeah, thanks for having me.
Yale, so I like to start every conversation with this quick question. I know you gave me a flavor of this last time, but for those joining us tonight, what inspired you to do the work that you do right now at Solo?
Well, I think to understand why I'm doing what I'm doing now, people need to understand my background. Um, I went to Indiana University, got an accounting degree, and I wasn't ready to go to work, so I went to law school. So I went to Ohio State Law School, graduated in 1992, and opened a practice with a friend of mine from law school called Pope and Levy. And we just hung up a shingle in the back of his dad's accounting practice, and we did everything civil. So throughout the process, we sent out announcements saying we opened our doors, please, we need business. And this woman called us and said, hey, I work at a collection agency. Would you like to help us collect some debt? Are you bonded? I had no idea what she was talking about. My brand new partner at Practice Law had gone to Hawaii on his honeymoon. I was there by myself. So of course I did what every young aspiring lawyer does and say, yes, I can do that. So before I knew it, back in 1992, I became a very teeny tiny debt collection lawyer that did some medical collections. So from 1992 to 2004, I slowly built my trade and learned how to do debt collection. I didn't know anybody in the field. I didn't have any relatives that helped me out. We basically did it with Excel and paper and pen. And then in 2004, we said, boy, this is growing. We decided to invest in a collection system called CLS. I went to my first national conference called the NCBA. And from 2004 to 2024, I grew my practice from just me doing everything myself to having 110 people in 5 states located in Ohio, Indiana, Kentucky, Maryland, and Virginia. Then I met a lot of people. I knew a lot of people during that period of time. I became president of the National Creditors Bar Association for 2 years. It was a great run. We had a lot of fun, did a lot of things, including engaging with the CFPB and lobbying Congress to modify the FDCPA to exclude lawyers.
Very cool.
Unfortunately, that never happened, but it was a great experience. And then back in like maybe 2022, 2023, a colleague of mine said, "Hey, I got an SBA loan. I would like to buy your law firm." They bought me out, paid it all up front, and lo and behold, the beginning of 2024, I was 54 years old and retired,
Mhm.
um, enjoying my life, walking my dog, is getting nice and tan, laying by the pool. And then out of the blue, one day, for no reason whatsoever, I get this LinkedIn message from George Simons, the CEO and founder
Yeah.
of Solo, and said, "Hey, we need some help with lawyers, getting them to engage with us. We don't really know any of them. Maybe you know them." And of course, I know a couple people. And before I knew it, I was hired. He flew me out to Salt Lake City. You guys can't see me standing up. I am 5'5" if I'm lucky. My boss is 6'8" almost.
He's a large man.
Yes, he is a very tall man. So if you could think of anybody taller than 6'8", good luck, but he is huge. So it was a great experience. I came on board. They taught me how solo settle and solo suit work. And it's been really great working for a tech company. Things move really fast. We're helping people every day.
Mhm.
Um, Not that I'm dissing my colleagues as collectors, they do a job that needs to be done, but I'm helping consumers understand that the solution to debt
Mm,
collection is not sticking your head in the sand and
mm,
hoping the account goes away, but it's communication.
mm,
Either hiring an attorney, picking up the phone and calling them yourself, sending them a letter, getting to legal aid, or using a product like Solo Settle. There's so many ways you could reach out and get your account settled. And
mhm,
what we have found is everybody wants the same thing, a viable settlement as quick as
mhm,
possible.
mhm,
So the only way that happens is if the consumer engages with the collector. If that doesn't happen, the wheels fall off. Typically, a default judgment gets granted.
mhm,
Once that happens, the law firm has the upper hand because
mm,
now a third party, aka the court and the judge, has said that this consumer owes that money, and now there's no dispute. And post-judgment remedies can be used to take money from you if you refuse to voluntarily pay it.
mm,
So I have got on the wagon now, and I tell people every day, yes, you need to communicate with your collector. You need to do it. Don't stick your head in the sand because
mhm,
that's the solution to the problem.
mhm. Yeah, no, I love that. Can you give us at a really high level just a definition of debt settlement? Actually, a couple things. What is debt settlement? What is bankruptcy, which is something we'll also be talking about? And then what does solo do as relates to those two things?
Cool. So there's, well, let me tell you bankruptcy first. Bankruptcy is something that the United States has created that allows somebody to get a fresh start,
Mhm,
wipe out all your debts, give away in exchange for taking your assets.
mm,
So if you have any non-exempt assets, the bankruptcy court would take those assets and liquidate them and give them to your creditors. That's called a Chapter 7.
mhm,
Chapter 13, which is a little bit harder to do nowadays, is a payout plan where you continue to work, you pay into the bankruptcy court, the bankruptcy trustee, and the trustee pays your creditors a percentage of what they're owed. Both at the end give you a fresh start, means your debts get wiped out and you get to start over. And that's what makes the United States so great, is that we give people the ability to get out from under their
mm,
debts if they need to, but the cost of doing that is it stays on your credit for 7 years. You can't file again for another 7 years. And you got to give up any assets that you acquired during that term that are not exempt. Debt settlement companies, I'm guessing is what you meant, Ben. Debt settlement companies are like the old Chapter 13s where
mm,
they ask you to pay money to them. They hold that money and then they try to settle your debts
mm,
with your creditors.
mhm,
They usually start with the smallest ones first and work their way up to the bigger ones so that they get some money in their bank accounts to pay your debts. There is a pretty hefty fee for that. It's not free. They are for-profit organizations, and they charge somewhere between 20 to 35% of the monies you pay in. Sometimes they don't always do things that are in the consumer's best interest. Sometimes they
Mm.
do. Lots of consumers are using it. It's become a billion-dollar industry,
Mhm.
and it has filled a lot of space that was taken up when Chapter 13s were changed about 10 years ago. What Solo Settle is, which is one of the products Solo has, is a consumer-initiated debt settlement platform that allows the consumer to reach out to their collector or law firm in a safe manner, without emotions, without fear, and try to amicably settle their debts
Mhm.
digitally without ever talking on the phone.
Hmm.
There is a fee to use Solo Settle as well. We charge a technology fee, and it's based on how much money you save.
Hmm. So
So
do you have to have been sued to use Solo Settle? I know you drew this distinction between the former type of debt settlement company versus settlement with Solo, and it sounds like those are two different things. So what's
it
the
is.
distinction there?
The distinction is the following. You don't pay any money into Solo Settle. You
Mhm.
pay as you go. Two
Okay.
is we don't have any skin in the game.
Mhm.
You are making your own decisions about how much to offer back and forth and how much you want to accept or settle. So
Okay.
you can make, Ben, if you were a consumer, you could have maybe a $5,000 debt. You could
Mhm.
offer $3,000 over 10 months of 300 payment, $300 per month.
Mhm.
And the collector or law firm might say, no, I want $4,800 paid over 12 months instead of $3,000 paid over 10 months. So that goes back and forth until the parties come to an agreement, and then we help facilitate the documents back and forth.
Mhm.
Solo Settle has a document process where the collector can upload a settlement agreement or confession of judgment, and we will send it to the consumer. The consumer will review it, approve it. They could docu-sign it and send it right back. So we try to make it as easy as possible for both parties involved. And again, at Solo Settle, we are neutral. We don't help either party except to help facilitate document and communication back
Okay.
and forth between the parties.
Gotcha. Thanks for that clarification. So we got a question from a user that I want to tackle here, which is I have two credit cards. One I'm currently being sued for. The other one is in collections right now. To avoid getting sued again, I set up a payment agreement with the collector in the second account, but I haven't made a payment yet. I'm worried. Could that be considered preferential payment down the line? And will this hurt me later? What do you think, Yale?
Well, Well, I guess the penultimate question, Ben,
Mm,
is does this consumer plan to file bankruptcy?
yeah.
If they don't plan to file bankruptcy, there's no concerns about preferential
Hmm.
payments. If they do plan to file bankruptcy, there is some concern about a preferential payment. This depends how big it is. If it's a
Yep.
couple of $100, I don't think it's going to really matter, but it could. If it's ten or $50,000, yes, that's going to be something that a bankruptcy trustee might look at. But I think the thinking was good to try not to get sued on the second one, probably
Yeah.
help with credit a little bit. But again, the one that's in suit, the one that's currently being sued, you need to contact or communicate with your collector immediately and try to get a settlement arranged. Because if they get to judgment, they'll be able to use post-judgment remedies such as wage garnishments or bank attachments
Hmm.
to involuntarily take money from you. That
Oof.
means they'll go in your bank account, take every dime you have, but for the exemption amount, or take up to 25% of your take-home pay if
Mm,
it's a wage garnishment. And again, you have no control over that. Once that gets filed and the court approves it and it gets sent to the bank or your employer, there's nothing you can do to stop it other than to pay off the debt in full.
okay. Got it. So one other thing that is interesting to me about this question, Yale, and I'm curious to see what you think. This person mentioned they have two cards, and only one of them's in collections. I'm wondering if this is even a situation where bankruptcy makes sense for this person. If they only have a few debts, how do you typically counsel somebody to decide if I'm being sued? Do I file bankruptcy? Do I try to settle? What do I do? Like, how would you think about that?
Right? It really depends on how much the debts are
Hmm.
and how much free income you have to
Hmm.
pay those debts off. If you have the ability in 3 to 5 years to pay those debts off, I would say avoid bankruptcy if you can, but you should seek bankruptcy counsel. I am not your attorney. I do not know your exact circumstances, but you could only file Chapter 7 once every 7 years.
Mm,
If you have only 2 debts that are in default and they're under $10,000, and you do have a job and ability to pay, and you have some non-exempt assets, then I would say try to get the cases settled for less than 100% on the dollar. We see it solo settle at the average settlement rate's about 72 to 73%. That's a pretty good deal. If you could get something in the 60 to 80% range, that's usually the sweet spot. If you have extenuating circumstances like specific hardship, illness, job loss, maybe the collector might go a little less. And it also will depend on how old the debts are.
mm.
If the debts are really old, you might be able to get a little bit better deal.
So this user is asking, what if I have no money to settle with? Can I just ignore the lawsuit? How would you think about this question, Yale? And specifically, I'm wondering how you would talk to somebody who's thinking about the idea of being judgment proof in a lawsuit.
Well, that's the ultimate question is,
Mm,
are you judgment proof? Do you have a job? If you have a job and you're getting paid every 2 weeks or every week, they can still garnish your wages if a
mm,
judgment is taken against you. If you have non-exempt earnings, or if you only have, maybe I'll make it easier. If you only have exempt assets, which would be Social Security, veterans benefits, SSD, SSI, public assistance, if you only have income that is considered exempt from attachment, and you don't own a house but you rent, and if
mm,
you have a car that's 15 years old, so it only has maybe $3,000 of value, and you don't have any money in the bank, there's a good chance that you could be judgment proof.
mm,
I would suggest that you go seek an attorney, a bankruptcy attorney in your jurisdiction, look at and let them know what you have, what income you have, what assets you have, and they can tell you if you're judgment proof or not.
mm. But even if you are, it sounds like you would still need to respond to that lawsuit.
Well, again, if you are ultimately, if you are judgment proof and you don't have any wages other than disability income, unemployment income, etc., you could, it doesn't matter if they get a judgment against you. What are they going to do?
Mm,
There's nothing for them to take.
sure.
So, and that's something you could tell the collector if they call you and say, hey, we're going to sue you. I would say to them, I'm judgment proof. I don't have any income that is not
Mm,
exempt, and I don't have any assets that are not exempt. So you can sue me if you want, but it's not going to do any good.
okay. Got it. So have to respond, may not, have anything that they can really do, but you need to get the ball rolling before that's going to matter.
Of course, I would always say the best thing to do if you're being sued is to respond, explain your situation, make sure it's your, and check and make sure it's your debt. I can't tell you how many times consumers in the last 9 months have told me that it was not mine or it's the
Mhm.
wrong person. That does happen
Yeah.
occasionally. So again, open your mail. That's number one. Look at what you're getting and make sure
Yeah.
it's yours. If it's not yours, stand up and say something. That's your right.
So, how should somebody think about multiple lawsuits? This was something that came up after our last conversation. I'm not just being sued by one debt collector. There's a couple of different debt collectors that are suing me. Do they roll together? Do I respond individually? Walk me through this. How should I think
Yeah,
about multiple
boy,
lawsuits?
the multiple lawsuits is a killer, especially for
Mm,
people living paycheck to paycheck.
mm,
Um, you need to respond to each one individually. That's going to take a lot of time and effort. You need to file an answer. You need to communicate with every collector that's calling you and try to get, well, I guess what I would do if it was me, I would make a budget and say, okay, how much do I have to afford to pay in total? And then try to work with the creditor, smallest to largest or largest to smallest, whatever you feel comfortable with, and try to divvy up that pie where you can make it work and to give everybody a little bit to keep
mm,
them from doing post-judgment actions against you.
mm,
If you have a job, if you have money in the bank, these garnishment actions will turn you upside down because you have no control anymore.
Hmm.
If you could enter into a settlement agreement, you have some amount of control where you could agree into what's coming out of your bank account or checkbook every month.
Hmm. Hmm.
So important.
I mean, does it make sense to prioritize one over the other, or is it really just best to kind of divvy it up and go through, paying off as much as I can to
Well,
each?
if they have multiple lawsuits, you kind of like doing a whack-a-mole, right?
Yeah.
Then all of them need to be addressed in some manner.
Hmm.
I would start with probably the smallest and try to get it out of the way or
Mhm.
settled and keep moving the way up. Some people I know do start with the biggest because it's the biggest one and
Hmm.
move the way down. It just depends who will work with you and who won't.
I mean, do the creditors or the debt collectors know about the lawsuits from other people? Like if I'm being sued by one person and somebody else is calling me, what happens if I just tell that person I'm being sued right now? Does it matter?
Um, it matters. Let's say in a scale of 1 to 10, 1 to 100, it matters a 10.
Okay. So not
They don't
much.
care. They got
Yeah.
the suit going. They just want to get to judgment, and then they
Yeah.
go for assets to execute on.
Okay. Got it. So this is a funny one. Somebody said, I heard someone talk about zombie debt with settlement. What the heck is zombie debt?
So
It's a fun
zombie
question.
debt is owed debt
Mhm.
where somebody has convinced the consumer to make a payment on it.
Mm.
So the zombie debt was dead because it was outside the statute of limitations. Then some collection agency sends you a letter and you pay $10 on that debt and it comes back alive because now you have re-aged the account and the debt that was out of statute is now back in statute because you made a payment on it because
Oh,
most
interesting.
state statute of limitations run based on the last payment date.
Hmm. I've,
So
I've heard some people say that, if like you're outside the statute of limitations, it's expired, you have a collections notice, even just responding to it can reopen that. Is that true?
responding to it were not real. At least in Ohio, where I
Hmm.
practiced, responding to it wasn't enough. Maybe in some other states it is, but
Hmm.
again, making a payment in a debt that is outside the statute of limitations is very bad planning on the consumer's part,
Hmm.
because in some states
Hmm.
that will re-age the debt and allow them to sue on it again.
Oh, wow. So you're saying if I have a really aggressive creditor, they're sending me collections notices. Let's say that statute of limitations already run, they can't sue me anymore. I decide to be nice. I give them $5. They could now maybe be able to sue me again on that
Correct.
debt. That's
Yes,
wild.
depending on the state.
Hmm.
Again, I'm not knowledgeable in all 50 states, but I know in Ohio that would reset the statute.
Okay. Interesting. So you've been on both sides of this process. What are some of the behind the scenes things that consumers don't realize about debt collection, the rules that debt collectors have to follow, whatever the case is, that you would love to share with people who are dealing with debt collection now?
Well, since that, I mean, the most of the collectors that I dealt with at the NCBA, which were
Mm.
lawyers, were very compliant with the Fair Debt Collection Practices Act.
Okay.
And that is the overarching federal law that governs how debt collectors can communicate and treat consumers. So so you could find it by Googling FDCPA, but for instance, debt collectors can't call before 8 a.m. or after 9 p.m. unless you agree to
Mhm.
it. They can't call you at work if you tell them that you're not allowed to accept calls at work. They can't, if you ask them to stop, what's called a cease and desist, they say, stop calling me, they have to stop calling you. They can't call you more than 7 times in a 7-day period. So
Hmm.
there's all these rules that are out there that have been set up by Congress, by the US government, to govern how collectors treat consumers and when and what they can do. So there are protections out there for you.
Hmm. So what motivates a collector to settle with you then? It sounds like there's a lot of things protecting you. Like, why would they have any motivation at all to settle and like deal with this? And vice versa, like why would you have any motivation to settle with them?
Again, as I said at the beginning, everybody wants the same thing.
Hmm.
They don't want to do additional work. So if they could settle
Hmm.
early in the process, there's a benefit to them because it's less
Okay.
work for the collectors, less work the consumers have to do.
Okay.
Consumers are working. Do they want to go to court hearings and miss work? No.
Mhm.
Collectors have to send attorneys to the
Mhm.
court all the time. They could probably save a lot of money if they don't have to go
Okay.
to court to attend those hearings as well.
So
So
your leverage is really like getting them paid faster and preventing them from having to deal with this lawsuit and all this sort of stuff.
for both parties. So everybody, the consumer and the collector, want the
Okay.
same thing: a quick settlement as fast as possible.
Okay. So I'm assuming the answer is yes here. I'd love to hear an example if you can share one. But have you seen cases that settled through solo that probably wouldn't have settled if people had tried to do it on the phone?
Boy, that's a great question. No, I think anything done through Solo could be done on the phone. However, so many consumers have this apprehension,
Hmm.
uh, talking to collectors, talking to lawyers.
Yeah,
Even
scary.
lawyers do this all day long, and
Yep.
they have all this their craft to
Yep.
know exactly what buttons to push, what to say, what to insinuate,
Hmm.
and consumers don't have that experience.
Yeah.
So for them, solo settle takes out all the emotion, all the fear, and makes
Hmm.
a level playing field where
Yeah.
all we deal with is numbers. How much can you pay, and over what period of time?
I don't know. Do you know Michael Bovey?
No.
Yeah, so he's a friend of mine who works in debt settlement. He used to be with a company called Resolve. And I was talking to him the other day, and we were going through a list of rules and sort of processes that all these different collectors follow. I was like, holy cow, like you call this person and they'll like offer you a settlement after 4 calls and this one after two and this one never. Like, how do you know this stuff? And like, how is a consumer ever supposed to know that, right? Like,
Correct.
that's really the value of working with an expert is knowing how hard you have to push and with whom and when and all that sort of stuff.
Correct. And law firms, especially, and collection agencies,
Yeah.
they want their cases settled. So they want these phone calls. They want
Yep.
solo settlers and debt settlement companies working to help them get the consumer educated to have that mindset that they need to pay something to settle their
Hmm.
debt.
Yep. This is a question we got earlier that I forgot to answer. I apologize, Tamika. Thank you for being so patient. But I want to do a Chapter 7 bankruptcy. Does my car note have to be current? So I'll answer this one as a bankruptcy question. So
Thank you.
no, you would be, it would be surprising if your car note was current. Most people who are thinking about bankruptcy, struggling with these things, fall behind. Car notes are often a big payment and people often fall behind on them. So it does not have to be current. However, if you want to do what's called a reaffirmation, which means take that car loan through bankruptcy, in order to do that, you'll typically need to be current or get approval to make it current post bankruptcy. So, doesn't need to be current unless you're planning to reaffirm it. And if that's a question you have as you're thinking about bankruptcy, the upsolve.org bankruptcy tool will help you figure out how to do that. Thanks for that question, Tamika. Okay, so another question we got here for you, Yale. What should I do if I never got properly served in the lawsuit process?
Well, service is a quintessential piece of the lawsuit process.
What is
To
service for those who?
service is that the summons was either placed in your hands or sent to
Mhm.
your home address and received by somebody. So to have a lawsuit, you need to be served with a copy of it for due process purposes. So under the US Constitution, everybody's entitled to due process, to use the court system. So if you're not served, you don't have due process, and a court cannot issue judgment against you. Now, sometimes the key word here is properly served. Sometimes you
Mm.
get service and it might not be proper, it might be proper. You just have to know the difference and make sure that it was proper service. If you're not properly served, you need to tell the court, I was not properly served by motion or notice, so that they could actually try to get you served in the right manner. If you were never served and
I think we
and,
lost you for a second there. Oh,
uh,
no, you're back. You're
if
back.
you were never served and the court thought you were served, but you weren't, and judgment was taken against you, you should
Mhm,
file a motion to vacate that judgment due to failure of
mhm.
service.
Okay. So this question, I'm gonna parse this a little bit. So we answered the second half of this question. Shouldn't ignore the lawsuit. That just makes things worse.
Correct.
So what if I truly have no money to settle with? And I'm going to make this a little bit spicier. I have some property that I might potentially lose. Like I'm not judgment proof necessarily, but I have no money with which to settle the lawsuit. What do I do then?
Well, could you? I guess I would try to sell the property I have
Hmm.
to get the lawsuit settled.
Hmm.
I mean, if it is tangible property that is sellable, that has
Hmm.
some value to it, that would be a possibility. The other option would be to file bankruptcy,
Hmm.
or you could have a judgment taken against you. Maybe the law firm or lawyer can't find the property you're talking about. Like if it's a baseball card collection, do they know you have that? Probably unlikely.
Hmm. I don't know. You should see some people's baseball card collections.
Yeah.
I
How
have a cousin. His house is about to fall into the center of the earth from his collection. Uh, I think I lost you there, Yale. You still
I
there?
don't. Yep.
Oh, you're back.
Okay.
All right. All right. So I think that takes us to the end of the consumer questions we have. So Yale, thanks as always for being on, answering questions tonight. What is one thing you'd like to leave anybody who's thinking about, working on a debt settlement with Solo, facing a lawsuit, thinking about bankruptcy, etc. with?
I tell people this every day. I said it at the beginning of this call, and I'll say it at the end of this call. Communicate, communicate, communicate. The only way you get these cases settled and avoid garnishment is to communicate with your collector, law firm, attorney, either by calling them yourself, hiring an attorney, getting help with legal aid, using Solo Settle, calling Upsolve. There's lots of options out there for you, but you need to communicate with them. That is the only way you get things resolved. If you stick your head in the sand, hope it
Mm,
goes away, it won't. They will automatically win, and then post-judgment activities such as executions, wage garnishments, bank attachments will happen, and they will be taking the money from you, and there'll be nothing you can do to stop it other than filing bankruptcy. So again, communicate, communicate, communicate.
So if people want to connect with you or explore more about what Solo can do to help them, where should they go?
They can go to www.solosuit.com. That is our Solo Suit product. If you want to see Solo Settle, it's www.solosuit.com backslash Solo Settle. And either of those sites will help you get there. We have lots and lots of blogs, webinars, YouTube videos that explain the process, explain what happens when you get a summons, tells you what to do when you've been sued. We have blogs about statute of limitations, everything you need to know about debt collection. We have it. It's free to use. Jump on board and see what it's like.
Awesome. Well, thanks again, Yale. Really appreciated having you on as always. Thanks to everybody who joined us tonight. If you found this helpful, please be sure to like this video and subscribe to the Upsolve YouTube channel. Also, check out Solo, as Yale mentioned. We do these webinars every Monday night. So if you have questions about bankruptcy or just debt relief generally, please feel free to join us for a future one. Share it with friends and family who might need help as well. Remember, you're not alone in this process. There are resources like Upsolve and like Solo out there to help you. Take care, everybody, and we'll see you again soon.
Thanks, Ben.
Thanks.